So we are now recording. There we go. Welcome to QLaw's Lunch and Learn CLE on LGBTQ plus housing and COVID-19. Before we go further, I want to acknowledge that we are coming to you from QLaw's offices, which are on the Coast Salish land, specifically the land of the Duwamish. And as part of that, it's important to acknowledge how we came to this land and what we can do to express our gratitude and give back to the people of the land who we're standing on today, and that we're housed on, thinking about this webinar, this CLE today. So if you don't know the land that you're currently on, I encourage you to find that out. Here, if you're on Duwamish land, Real Rent Duwamish, which we have at the bottom of this slide you're seeing, is a great resource, a great way to express gratitude back. Also, whether you're here in Duwamish territory or elsewhere on Turtle Island, giving to Native nonprofits that help the Native peoples of the land is always great. So letting you know what we're going to be covering today, doing our introductions and agreements. Then I'm going to go into sharing with you some of the impacts of COVID-19 on LGBTQ plus communities and housing. And again, our apologies for the technical issues on Friday that didn't allow Josh to present. And also we heard there was a lot of cross noise from people unmuted during mine. So we're just going to do the whole thing from the top for you. Then Josh is going to go into post-COVID-19 eviction moratorium and representing LGBTQ plus tenants. And then we'll do some Q&A and knowledge sharing. So disclaimer, as I'm sure you're all aware of, this information is presented for educational purposes, educational and informational purposes only, not to be considered legal advice, does not constitute the creation of an attorney-client relationship. So introductions, I am Jessie Guecha. My pronouns are he, him. I am a community legal resources manager with QLaw. I have been a Washingtonian for 40 years. And 12 of those years as a renter. And this is?
My name is Josh Treybig. I use he, him pronouns. I am an attorney. I currently work at the Seattle Office of Labor Standards. I am a 17-year Washingtonian and a 14-year renter.
So agreements for the day, and not a full day, but for this lunch and learn, move up, move back, shared assumptions, unequal systems do definitely exist, including the legal system. Treat each other with respect and dignity. Anyone can harm and be harmed. Something I've recently learned from a coworker is HALT, which stands for hunger, anger, loneliness, tiredness. If any of those things are happening, it's probably due to unmet needs. So it's important to take care of our needs. Also, make sure you have food and water. It's a lunch and learn. You're definitely welcome to eat. So a little bit of an intro about LGBTQ plus people in Washington. We are 5.2% of the overall population in Washington. 29% of us are POC, 28% raising children, 57% are under age 35, 25% are food insecure, which is really high, over double 12% of that in the general population. and 22% have an annual income that is less than 24,000 annually. So LGBTQ economic impacts of COVID in general, LGBTQ communities were already impacted, and COVID has just made everything even more so. So poverty rates in Washington, more than 30%, 36% have incomes at or below 200% of the federal poverty rate. Nationally, 40% of LGBTQ plus people work in the top 5 impacted industries, almost double the general population. So another area where our communities have really been hit. And then also, looking at the information out there, 20% of people in our communities report not requesting sick or caretaker leave due to fear of discrimination if it were to require disclosing their LGBTQ plus identity. So that definitely is something that has unfortunately played a role for people during COVID. So some housing challenges for LGBTQ plus people. So these are things that may be taken into consideration when you're doing an intake or you're working with clients that have these identities. And again, these are challenges that have existed for quite a while, well before COVID, but now they're even more magnified. So due to employment discrimination, other marginalizations, COVID factors that we talked about, people in our communities may not have an acceptable credit score to be able to rent or purchase a home. They may not have the income that's required by the landlord to rent. Sometimes they want 2 times, 2.5 times, 3 times the rent. And unfortunately, some people in our communities just don't have that. Same when it comes to having money saved for move-in costs. And specific to Seattle, city of Seattle, a few years ago, there's an ordinance that came into place where payment plans have to be offered for the deposit fees and last month's rent. So everything but first month rent. But in practice, this is still an issue because if they have somebody else that's has that money up front, from what we've heard, landlords are just going with that. People in our communities, and I'll talk about this a little bit more in the next slide, but may not have official previous rental history. If they were living off lease or subleasing or things like that. Also, sometimes people need parents to co-sign, but sometimes people in our community don't have that an option available to them. So when we're looking at LGBTQ plus housing situations, things that your clients may be experiencing, or when you're looking at doing intakes, likely to be in rental housing, more likely to live with roommates rather than nuclear or extended family. We also see a lot of non-standard rental situations. So maybe someone in community actually does have a house, but then they convert the garage so someone else in community can be housed. Illegal or unpermitted units, in borrowed space off lease. Maybe there's a house and there's 10 people renting 10 different rooms, but really only 2 people are on the lease. When you actually look at the lease paperwork, there may not even be a lease. That's something else to consider. Unfortunately, people in our communities are likely to experience rental discrimination and then also be fearful about reporting that due to retaliation or having fear that they'll be able to find new housing. Shadow evictions, unfortunately, are also common when rather than using, or because they can't use the eviction legal proceedings, a landlord just makes it very uncomfortable for a tenant to stay so that they voluntarily leave, but only because of not good actions by the landlord, or, you know, even like throwing people's things out, etc. And you know, most impacted are trans and non-binary people, PD BIPOC people, and queer and trans people with disabilities, unfortunately. So evictions, and Josh is going to go into this a lot more, but some things that community are concerned about is what happens after the rent moratorium ends. We have the statewide rent moratorium that goes through the end of this month. So things that, you know, can, things that could be helpful to them are rental assistance programs, negotiating payment plans with landlords, understanding their rights. The moratorium, it looks like it's not going to get extended again, but the good thing is there's a lot of new tenant rights, and Josh will go into that more. And then, you know, people are needing help kind of understanding, you know, how things are going to get implemented. We have the new right to counsel, but there's up to a year technically given to implement that, and the mandatory mediation pilot project that landlords need to go through before proceeding with evictions, but only once those programs get started in the counties. And then shadow evictions continue and will continue, unfortunately, to be an issue. So helping people know what their rights, what's legal, negotiating repairs, lease extensions, and then discrimination is something also that, you know, I've heard about a lot in community, and people, you know, have questions about what they can do in different situations. And as far as housing discrimination, some of the things that we find helpful for tenants to consider and people to consider at different points is when they're applying to rent, what information did the tenant potentially share, or the potential tenant share? If not in the application, maybe unofficially. Maybe they are masculine presenting and they referred to their partner with he, him pronouns. Maybe they brought their kid along with them, you know, when looking at the apartment. What are some things that the tenant or that the landlord might have concluded and now be using to say like, oh, suddenly that unit's not available. When tenants are housed, and then questioning whether the landlord's discriminating against them, you know, one of the things that barometers that we ask people to consider is, are tenants with other identities treated better? We're also seeing things between housemates, escalation of conflicts, in-group, out-group dynamics, harassment. Also, in meeting with communities and LGBTQ groups statewide, one of the things we heard about was harassment from neighbors, unfortunately, and whether that's like a noise complaints, even though like the queer house is no louder than any other house on the block, or actually to the point we heard of neighbors using anti-harassment legal proceedings against LGBTQ neighbors inappropriately as a way to discriminate and actually harass. So one thing that I'm working on and going to be coming out with soon is a housing guide for our LGBTQ plus community. So I am putting in common situations and how the law applies. So like if you owe back rent from the moratorium, can my landlord do this? What if I'm not given a lease document? Getting evicted, someone can't make rent, or what if they can make rent, but a housemate can't, being discriminated against. And also one of the things that we find out that we found too can be helpful is giving people alternatives for resolving issues without going to court, since going to court can be something that people in our community don't necessarily want to do. It can not be the best experience. So learning to document things, writing letters, negotiating with a landlord, and those are all things that that legal providers can also help people with. We're also going to put resources from housing orgs across Washington State, but also really interested in anything else. And you can put in the chat or you can email me that you'd like to see based on what you're seeing in community or what clients are coming to you with. If there's some like commonly asked questions or things that you would like clients to have kind of like prepared or documented or something before coming to you. And when that is out, we'll post that to our website and our social media. And we'll turn it over to Josh.
Thanks. So following up on some of the introduction I gave earlier, I'm currently working as an investigator at the Seattle Office of Labor Standards. I've been a longtime volunteer attorney in the QLaw Foundation Legal Clinic. And previous to my current job, I worked for the King County Department of Public Defense, where I worked in what is called collateral consequences, which is a fancy word for saying all of the civil legal things that happen to folks who are involved in the criminal legal system that's not necessarily part of their sentencing, but has a very direct impact on their life because they've been involved in the system. I also volunteered for a while with the King County Housing Justice Project, and during law school, I interned at the U.S. Department of Housing and Urban Development, which was doing fair housing enforcement. And again, as I said in our introduction, that I've been in Washington for about 17 years now, and I've rented for 14 years, which I think is important to note, because one of the things that I think is most important about even providing this information is that I can't even think of how many times my rights were probably violated as a tenant, and I just had no idea, because we are so used to the power dynamic that landlords tend to hold over tenants. And so hopefully we can provide some information to help folks represent tenants better and provide better information so folks just know where they stand and where their rights are. So again, just as a disclaimer, again, this is just for educational and informational purposes. This should not be considered legal advice, and to any extent, I am providing opinions. They are mine and not those of the Seattle Office of Labor Standards nor King County Department of Public Defense. So why does fair housing matter? I got very invested in housing rights because I realized that it is a nexus of so many other civil rights issues. Where you live usually dictates where your kids are going to go to school. It dictates whether you've got a grocery store on the corner or you're living in a food desert. It can define the amount of pollution that you're exposed to, your access to public transportation. These are all intimately connected to your housing rights and ability to live where one would choose. And so it can be a path to opportunity, or you can be entrenched in the long-lasting discrimination that has become part of housing law in Seattle and across the nation. So just to give a little a little bit of background on legal protections and fair housing. Congress passed the Fair Housing Act on April 11th, 1968. And at the time, it covered 4 protected classes: race, color, religion, and national origin. It's been expanded since then, where sex was added as a protected class in 1974. Disabilities and familial status were added in 1988. There are also protections against source of income, which means that that a landlord cannot discriminate against a tenant based on where their money is coming from, whether it's from Social Security disability, or it's from a beneficial family member. And then the federal government during the Obama administration also extended sex-based protections to recognize sexual orientation and gender identity. And if you saw the movie about Ruth Bader Ginsburg's life on the basis of sex, basically the decision was very straightforward, that one could not discriminate against someone's sexual orientation or their identity without immediately being discriminating based on sex. The last administration rolled back those protections, but the Biden administration has reinstated them. Lastly, marital status and sexual orientation and gender identity are also specifically protected classes in Washington. For the attorneys out there, we know that the federal protections are the baseline, and Washington State is more protective. And then based on the county or city that you're working in or representing folks in, that the protections are usually greater. So Washington does afford additional protections, particularly relevant to our community. So this was my one shot to get a meme in this presentation. And I think it's particularly funny because of the word discrimination. And if you've seen Princess Bride, I believe he was talking about, I can't even think of what the word that they were talking about was, inconceivable.
Yes.
And you don't know what that word means. And I think for most of us who are involved in the legal community, we understand that in real life, we recognize discrimination happening all the time. And under the law, it is extremely difficult to prove that discrimination is happening, but that doesn't mean that it's not happening. So I think that's one of the things that's very important to consider in landlord-tenant disputes when it comes to representing folks in our community, that is a landlord factually discriminating such that it would meet the definition under the law, or is it, as our esteemed leader Denise Diskin has called it, a big stinky fact? And it is often a big stinky fact. So in 2021, as we probably realize that we are in some ways a more racially segregated society than we were 50 years ago when there were first legal protections under housing rights. One of the key parts of that is what's called redlining, which was a federal policy that was adopted from the 1930s to the 1960s that explicitly said this community has different loan worthiness than other communities. So in the context of Seattle, these policies said that the Central District generally was not as creditworthy as other parts of the city. So without naming specifically that, primarily saying that Black people cannot live here, the credit policies of the banks that had to give out loans so that folks could buy houses essentially made it such that people of color could not get loans to live in so many communities. And this is true of Compton and East LA. It's true of the South Side of Chicago. It's true of Harlem and Brownsville in New York. And it's true of the Central District right here in Seattle. But as most discrimination exists in 2021, it's not outwardly placed. It's not overt. It's not that a lease is saying that people of color can't rent here. Housing discrimination is occurring in many different ways that is not as immediately recognizable. So how does discrimination happen when you're renting if it's not immediately saying that a queer person or a person of color can't live here? One of the most common ways is that a landlord is just going to not rent or sell a property to someone. And they may have different reasons, but in Seattle, at least, there are particular protections that mean they're called like first in time protections, which means the first person who applies for a lease and is eligible to rent there has to be offered the opportunity to rent there. But how does one know that? I just signed a new lease and I don't know that I was any sooner than anybody else in filing my lease application. Discrimination in advertising. It can happen very overtly, like saying somebody with a felony cannot live in this building, or it can be very subtle. Lying about or misrepresenting availability. This can happen where one sees an ad for an apartment and they call up and the landlord says that it's no longer available, but it actually is still available. Changing the terms or the conditions of a lease agreement. Landlords are required to be offering all people under their tenancy the same leasing conditions. They can't just add a specific item because of the population that they're renting for. Steering is very difficult to recognize, but steering is when there could be a property management company that is taking a rental application and they're saying, well, there's not a unit available in this building, but there is one down the street or down the block or in a different neighborhood, so that they are directly steering people into different housing than the folks are actively applying to. And then the different terms or conditions on a loan. That if, barring a credit score, that landlords cannot have a different rate of interest on a loan, or a bank cannot offer different interest rates on a loan based on an individual's protected status, sexual orientation, gender identity, or race. So as I said, I took this straight from our esteemed leader, Denise, who said, discrimination is a big stinky fact. So discrimination under the law may not always be happening, but judges do not want to hear about discrimination happening at all. So it can be a key litigation technique to make it well known that you feel like your client has been discriminated against. And it can happen in so many different ways. The key legal way that it happens, or illegal way it happens, is by retaliating against somebody for filing a complaint. If they file any sort of complaint against their landlord for needing repairs to be done, about an issue in the apartment building, it's on its face retaliation if the landlord then tries to evict someone within the next 90 days after filing that complaint. Creating a hostile environment. If landlords are just refusing to return their tenants' calls, acknowledging that there is a repair issue that needs to be taken place, if they are letting another tenant harass somebody else in the building, it can be creating a hostile environment. This is, what was the term that you used for shadow evictions? I think the legal term is probably, oh gosh, it's a shadow eviction.
Shadow eviction I got from Denise as well.
It's landlords making the situation such that a tenant would rather move out than maintain their tenancy, which can happen via sexual harassment directly from the landlord themselves or the landlord allowing it to keep happening from one tenant against another. And then lastly, failure to provide a reasonable accommodation. As Jesse was talking about, our community has disproportionate representation as folks with disabilities. And if there is a tenant that requests a reasonable accommodation, then the landlord is required to provide it. And refusing to do so is another way of just discriminating against our community without saying you're discriminating against our community. So there have also been, fortunately, some additional specific rental protections that have come into place since the COVID-19 pandemic. Even though that the eviction moratorium is scheduled to end at the end of this month, the law states that eviction for non-payment of rent cannot be filed. Landlords cannot hold unpaid debt as a reason to evict folks. But I think the key question is, what exactly does that mean as it plays out in the law? The protections say that if you are unable to pay rent or facing a hardship because of COVID-19, and how that's actually going to play out, as far as I know, is really a mystery, because these cases just have not been able to go to court yet. So what does it mean to have a hardship that's due to COVID-19? Is it losing your job because the restaurant you worked for has closed down? Because as Jesse was talking about, a large portion of, or I should say, more people in the queer community are working in food service, hospitality, industries that were more heavily impacted by COVID-19. But how that actually plays out in court is really a large unknown. So when you're representing a tenant, use all of the ambiguity to your benefit, and make it very clear, as Jesse was talking about before, that our community is disproportionately impacted by COVID-19, by the industries that more of the queer community works in, and bring in all of these facts to help make your case, if not legally stronger, to make it more sympathetic to the judge who's probably going to be hearing it. So when we talk about representing the LGBTQ community in housing or in really any capacity, is to provide respect. It's the most important thing that we can be doing as attorneys. Discrimination is a big stinky fact, but that doesn't mean your client wants it to be used that way. It could be very apparent to an attorney that discrimination is happening, but for all the reasons that Jesse spoke about earlier, folks in our community can just be avoiding the legal system at all costs. It could be that they just simply do not want to deal with how a judge or attorneys are hearing or not hearing their story. It could be whether or not a judge or an attorney is dead naming someone, or it could just be that they, like so many people, have traumatic stress, and the idea of going to court is terrifying for them. So one of the things that you have to do in realizing that you've got this big stinky fact happening is ask your client how they feel most comfortable having this fact integrated into their legal representation. Do they want it to be brought up before the judge? Would they be more comfortable if this is just brought up to the opposing attorney, and having them aware that this big stinky fact is out there without actually presenting this in court? Is it something that they would rather have this talked about in the side conversation, or do they want to wave this big stinky fact in everyone's face and make the court and attorneys know that it's existing? So the best way that we can all provide the best representation to folks is by making sure that we're on the same page and knowing how comfortable they are with these facts being brought up. And then when attorneys and their clients are on the same page, they're not only going to be more comfortable, but they're actually going to be able to, they're going to be able to provide the best representation. So again, representation strategies. I think one of the things that we are most likely to forget as attorneys and folks in the legal community is that sometimes the best option is to not go to court. If you're a tenant and you have an eviction case filed against you, that's enough. The tenant can win their case and there's still going to be a blip on their record that is going to be difficult in the future when they try to rent from a landlord. So it's best to stay out of court. One of the things that I really hold on to that I learned in civil procedure and law school was that civil procedure is the gateway to the courtroom. So whether or not there are payment issues, discrimination, if your client is possibly causing some legal issues that could lead one to getting evicted, have the procedures been followed correctly? In my experience, they are so rarely followed correctly because tenants are usually going into court or going into this legal process not knowing what their rights are, not understanding that they have all of these defenses available to them, but the landlord could just simply not be providing notice correctly. There are specific notice requirements, and if they're not followed correctly, then it can be the saving grace for any tenant to stay in their apartment or to just have more time to get everything sorted out. Did they serve it in the correct way? Was it posted on someone's door? Was it mailed? Was it by certified mail? There are so many specific legal procedures that are required. And if a landlord is not following those procedures, then it can be everything that matters for a tenant to be able to at least have the opportunity to defend their case. So again, yes, how to avoid court. The landlord following the correct notice procedures is one of the key things. I think one of the other biggest things that I hear from tenants who've come to the QLaw legal clinic with issues is that they're facing an eviction, but their landlord has not provided repairs that were required in time. Folks who were left in January and February without working heat, and their landlords just didn't do anything to repair it. One of the other things that Jesse highlighted well was that many folks in our community are not in traditional leases and not in traditional relationships. So that can make it additionally complicated to try and reach a resolution in housing court, because landlord-tenant law is laid out in a way that really does not make sense for so many modern relationships. I think landlord-tenant law was written assuming that there was one man and one woman married, moving into a unit with a stable income and no criminal history, and that's the assumptions that they made writing landlord-tenant law. And we just know that that's just not the case for so many folks in our community. So understanding that the different relationships that folks are coming to you with and the way that might make landlord-tenant relationships therefore more complicated is something that's incredibly important to be cognizant of. So some of the existing protections in Seattle, the Seattle City Council has just passed some legislation in one of the council committees that's adding 3 additional protections to tenant relationships within Seattle. One of those is that there cannot be, as called the school year eviction protection, which exists for folks who are teachers, who are students, or who are parents of students, and requiring the landlords to go through additional steps to evict any folks in those relationships during the school year. Another requirement is called the just cause requirement for non-renewal of leases. Many of us who've lived as tenants for a while, we expect that our lease is just going to be renewed if we decide to stay on for an additional year. But many landlords simply decide to not renew a lease. And in Seattle, at least, they are going to be required, assuming this bill gets passed by the city council and enacted into law, is that landlords will be required to have just cause for not renewing leases. They can't just decide that they're not going to. They're going to have to provide cause. And lastly, one thing that's I think is important to remember is I think so many of us think of Washington and Seattle especially as being extremely progressive. We think of ourselves like really as a standout among the nation as far as having progressive laws and rental protections, but rent control is not allowed in Washington. It's been disallowed by the state legislature. So the idea of rent control, which I know so many folks across the nation think is like the gold standard of rental protection, it doesn't exist here. So rents can just keep growing as long as landlords are giving enough notice. And that sort of protection just simply doesn't exist in our state.
Josh, we have a question from the chat on that. Is non-payment of rent considered just cause?
Well, non-payment of rent would be, my understanding at least, would be that would not be just cause. My understanding of just cause is that it would be someone is not renewing a lease based on damage that they're causing to the apartment, harassing fellow tenants. I do not believe non-payment of rent would be just cause. But again, this is a very new Seattle protection, and I cannot say how that actually weighs out unless you know.
Like for eviction, non-payment of rent starting July 1 will resume being a thing when the moratorium ends. But for this renewal of lease, because it's still pending too.
Yeah, it's still pending, so it still hasn't even been enacted into law. I think one of the things that's very key to provide, as this last slide shows, is important resources, because the housing issues that folks can be facing can just be so incredibly complicated. One of the key places to go to is housing justice projects. King County and Pierce County each have incredibly well-staffed housing justice projects that work. In King County, they operate right out of the downtown and Kent courthouses, able to provide eviction defense on the day of. They've also done an incredible job of just being available and helpful remotely, since we're not able to meet in person for a lot of cases. As there has been additional protections enacted in Washington that are providing folks the right to counsel based on certain income requirements. The Northwest Justice Project, who has offices throughout the state, will be hiring, I believe, 20 housing defense attorneys, I think 8 in King County alone. So they will be coming incredibly well staffed and able to help defend tenants who are facing eviction. 211 can be a pain in the ass to actually get to someone and get the information you need, but it is there, it's available, and when you speak to someone, they are incredibly helpful. The QLaw Foundation Legal Clinic, it has been such a pleasure to represent folks, or not represent folks, work with folks through the QLaw Foundation Legal Clinic, and it's an incredibly important resource for folks in our community. WashingtonLawHelp.org is actually, it's maintained by the Northwest Justice Project, and it has many forms, explanations of processes about housing rights, about landlord-tenant defense, and about so many other legal issues that that folks in our community are facing, and ideally has many processes that help folks walk through them themselves, that way that they can best advocate for themselves. I would also, for folks who are looking to consult with a volunteer attorney with our legal clinic, you can go to QLawFoundation.org. There's a link to the legal clinic, and you can provide the information that you need to schedule an appointment, and you can get matched with myself or one of the other wonderful legal clinic volunteers for additional assistance. And like any legal clinic, whereas as Jesse pointed out, this is not, none of this information is attorney-client protected, but all of the folks who come to us in the legal clinic are protected by attorney-client privilege and equipped by incredible volunteers who are able to provide research and information and forms and everything that hopefully makes the legal process less scary, and at least, if nothing else, a smiling face and a friendly person who's able to provide assistance to folks.
Definitely. And I checked the chat, but I didn't see any other questions. Are there any other questions?
We did have one that came in that I thought was a great suggestion that came into direct message to me. And it was a comment coming from a fellow person in LGBTQ community, and just something for us to think about as a group of folks is that, you know, as a queer community with access to a lot of resources in the legal profession, where we can redistribute funds and redistribute economic resources, there are a couple of specific projects that I wanted to uplift and that this person wanted to uplift, that is specifically working with queer and trans, BIPOC, so Black, Indigenous, and other people of color communities, including Queer the Land, which is a Seattle-based collective that just actually bought a house on Beacon Hill to provide, and they're in the process of fixing it up and making it kind of a community space that will provide housing directly to trans BIPOC folks who are experiencing homelessness, because we just see so many folks in very dire situations. Similarly, the Trans Women of Color Solidarity Network is a really wonderful collective that collects and redistributes funds directly to trans women of color and femmes of color, and also recently got was able to purchase a couple of buses that they are in the process of converting to mobile emergency housing. And I believe Gender Justice League also has trans inclusive emergency housing available both at their office in Seattle, and they're in the process of opening up new housing, emergency housing for trans women. And I want to say they actually just told me like yesterday, it's in Grays Harbor and out on the peninsula. So there's some really good, and I believe potentially in the Thurston County area. So there's really, really wonderful opportunities, and to support, you know, those collectives and groups, and also to just know about them, because so often when we're representing folks in these housing situations, you know, the legal question is sort of one side of things, but on the other side of things is, you know, what does the person actually do, right? If they're in a situation where, for example, they might be harassed by a roommate or by a landlord, right? You can deal with the legal process, but that legal process is going to take time, and that person is going to need someplace to go in the meantime. And that's a place where queer and trans and communities, and particularly QT BIPOC communities, have really shown amazing innovation and connection. And so those are really great things to know about. and really wonderful things to support. So I just wanted to lift that up. And then I have one other area actually that I wanted to, if I may, ask about is for Josh. I'm interested if you could share a little bit with our folks here about some tools that you have seen for using either rules of evidence or other types of sort of representation tools to effectively represent queer and trans people in court. You know, and because I know how often, for example, dead names might be used to, you know, you might have a legal proceeding that's brought under a person's dead name because that is still their legal name. And I'm wondering if you have insights that you can share about how to, you know, sort of de-weaponize that in the adversarial process, or if you have thoughts about how to kind of talk to judges about which name and pronouns your client uses to kind of make sure that the courtroom is as, you know, as affirming as a courtroom can be, which is sometimes not very. Thanks.
Yeah, thanks for asking, Denise. I think that is a really good question. I think the rules of evidence, I think, are really difficult in housing law because the courts themselves are so used to folks being unrepresented or just not being represented and having no particular legal background or knowledge of what they're going into. So I think the evidence can be very difficult because the judges kind of expect that the normal rules of evidence aren't going to apply. They do apply, but just evidence can be so difficult to provide. I think Jesse said earlier about the importance of documenting everything. And I think that's one of the most important things that folks can do. If you're having a text message conversation with your landlord, to screenshot it, print it out, whatever you can do to document the fact that you've had these conversations, if it's about repairs that need to be made, if it's about a fellow tenant who's harassing you, whatever the reason is to document it. Screenshot it if it's in a text message, if it's in an email, awesome. But you cannot rely on, obviously you can't rely on verbal conversations. So much happens between landlords and tenants that's very informal. So if you have a phone call with your landlord and are discussing any of these issues, follow up with an email. That way that it is written up, and you know, if it's nothing more than thanks for your time. This is what I understand our conversation to have been about today, and this is what I'm expecting to happen. That way that you're just as crystal clear as possible to be able to prove that this conversation did happen. This just occurred to me from what you were talking about, Denise, but some of the other protections also that are very relevant to our community, the queer communities, and to the COVID-19 pandemic. We know that domestic violence has been skyrocketing because folks are often trapped at home with their abuser, and it's very difficult to get out of. But there have been protections for survivors of domestic violence before COVID, and extremely relevant now, that if somebody explains to their landlord that they need to break their lease because of a domestic violence situation, the landlord is required to allow them to break their lease. Unfortunately, you are still required to provide a copy of the domestic violence protection order or evidence that you're pursuing this in court, which, as everything that we've been talking about why queer people don't want to go to court, is exponentially more if you are a queer person and you're experiencing domestic violence. So I think it's an unfortunately it's an overly high burden, but it is something that is very important for folks in our community to know, is that they are not required to stay in their home if they're afraid of breaking their lease, if they want to get out of their tenancy because of a domestic violence situation that they're experiencing.
So our chat is pretty quiet right now. I will just remind folks, please do drop questions into the chat if you have them. So I'm kind of gaming this a little bit by introducing more questions, but thanks for humoring me. One, I'm really glad you raised that, Josh, because we do within LGBTQ communities, and particularly through our legal clinic, we do see a ton of folks who are survivors of domestic violence. And one thing that I wanted to actually run by you, Josh, is that my reading of the domestic violence statute is that because it includes anyone that you live with, whether you are in a romantic relationship or not, it's sort of, separate, those are separate elements under the statute. My interpretation of that is that domestic violence protections also apply to housemates. So if you have a housemate who is abusive or harassing, even if you are not in a romantic relationship, my reading of the statute is that those folks, that those relationships are encompassed under the domestic violence protection statute. Would you agree with that?
I would agree. That's my read as well. Fortunately, I haven't had to take a case where that's been the situation, but that would be my read as well.
Yeah, thank you. I just think it's helpful. We often find, folks having conflict with roommates, and I find it very helpful to be able to sort of point folks to the right resources, because there are a lot of really great procedural resources on domestic violence protection orders, and the ability to receive those. So that's a helpful thing for us to have in our back pocket for sure.
Absolutely. And I think one of the other things that's helpful for folks just in general to know, if they're not familiar with the QLaw Foundation Legal Clinic, is that folks who are looking for legal advice or assistance don't have to have I say this all the time to folks I'm trying to pitch volunteering, is you don't have to have a gay legal issue. Like, you can just have a landlord that's an asshole, and it could have absolutely nothing to do with discrimination. Yeah, I mean, I think one of the things that people forget about representing our communities is that we are just regular folks who are trying to go about life and facing legal situations, and it may or may not have anything to do with our identity. And the wonderful thing about our legal clinic is that we're there for folks.
And Denise mentioned a lot of good resources for especially QT BIPOC folks, Trans Women of Color Solidarity Network, a great network that helps, definitely helps folks if you're looking to support also Queer the Land. Another resource, and this is just in the kind of immediate, but I want to make sure everyone's aware of, as you come across clients or people needing help regarding back rent for COVID, related to COVID-19. County by county, there are various programs. I know in Thurston County, I attended an NJP webinar and found out about a program in Thurston County that for folks, again, you don't have to be just regular, folks, but that includes our community, that are behind on rent. This program can pay, currently it's related to COVID, but it can pay 12 months of back rent as far as 3 months of rent forward, which, just in that can solve some of the issues that people are facing. So those are temporary COVID related things, but definitely something to look for county by county that can be a huge resource for people right now.
Absolutely. And I hate like bringing up the things that exist in Seattle so often, but that's where I practice and what I'm familiar with. But we've been very fortunate here in King County that the Seattle Mariners, of all random entities, have given a bunch of money to help folks who are facing eviction only because they can't pay rent. And it has been wonderful to be able to walk somebody through that process and just get the assistance they need if when that's been the thing that's holding them back and leading with a potential eviction on their shoulders.
Thanks, Josh. You know, it's funny, I follow a Twitter account called Did the Mariners Win? And it just answers yes and yes or no for each of the Mariners games. And it looks like they are definitely winning on that one. I did just want to lift up one note that came through in the chat. Confirmation from one of our colleagues out in Spokane who confirmed that the DV statute does apply to roommates and ex-roommates. So I'm really glad to hear that. I'm especially really glad to hear that from Spokane, because I know that as you know, as folks around the state, you know, can certainly attest, different counties and different sort of sets of benches sometimes have different approaches for and broader or narrower interpretations of things, and or can be harder or easier to kind of make certain types of legal arguments that bring inclusivity to our communities. So I'm really glad to hear that, and really glad that we have folks from all the way out in Spokane joining us. Thank you.
Any other questions?
While folks are chewing on maybe one or two last questions, I'll just make one more plug for our LGBTQ legal clinic. If you are interested in becoming a volunteer, if you're an attorney and you've got some extra time, you want to work more closely with LGBTQ communities, we actually are going to be doing a new volunteer training later this summer. Because we, frankly, our clinic is booked out about a month right now, which is obviously not super helpful for these types of quick legal questions. But we are working to actively grow our attorney pool to support with that. And you don't have to have any particular area of expertise, even in civil law. We have everybody from, you know, partners at giant law firms, to general counsel at giant companies, to folks who are doing civil legal aid. It's a really broad mix of folks, and we provide legal support in terms of research and things like that to kind of help you with your client conversation. And the other thing I'll mention is that one of the things that we work really hard to do is to work directly with our colleagues that provide direct and long-term representation. So if you are at a housing justice project, if you're an NJP attorney, if you're at a law firm, you know, that is interested in sort of receiving referrals from our LGBTQ legal clinic, those are relationships that we are always working to build, and we can, you know, help you in, you know, making sure that your internal proceedings are inclusive if you're worried about that, or if you're not worried about that. It's always just good for us to have a conversation so that we, you know, often one of the difficulties with our communities is that we, because we're not measured in so many different demographic ways, or our legal issues are sometimes a little bit off the wall, it can be hard to know what resources are safe to send our communities to, and it can be hard to know kind of how to help legal services providers understand the deeper context for our legal questions, particularly when they're a little bit different than the norm. And so we are always working to build relationships with legal organizations. So we would be more than happy to chat with you and put you on our referral list, and and talk with you more about other kinds of collaboration efforts, because that's a big part of what we do, is connect our communities to the legal services providers in your geographic area. LGBTQ communities shouldn't need to come to a Seattle-based legal resource to get assistance that is, connected and informed about what happens for our communities. So it's a big part of what we do.
If you're not sold on volunteering for the Foundation Legal Clinic, I just have to +1 everything Denise said. I, like most attorneys, can get very exasperated and tired of one's day job, but you take a shift in the legal community and you immediately see the difference that we're able to offer to the folks that we are able to assist. Because the thing I like most about being an attorney is that I've been able to take the extraordinary privilege and education that I've had and use it to help bridge the gap between folks who need legal assistance and the legal system. Because I think any of us who've ever tried to read a legal case and are wildly confused by what these words mean, recognize the difference you're able to make by helping folks bridge that gap. And not just by understanding what the law says, but because just interacting with the legal system is so scary. And helping somebody else do that, doing it with them, empowering folks, it's an incredible experience. And if anything, our clinic has just massively stepped up in the last year, where I don't even know how long we've talked about we should really have some sort of virtual or remote option. And then COVID-19 happens and we go virtual and we double our capacity. And it's wonderful that we've been able to step up that capacity. But as Denise said, the clinic is booked out a month out, and it just speaks to the level of need that our communities are facing. And if you are able in a place to financially or personally step up to help meet that need, by all means, join us. It's fun.
Definitely. And I think, the clinic is an example, and volunteering at the clinic is an example of where just knowing a little bit of legal information, and we have interns that also do research and things like that, since we realize people have day jobs, can be huge just to somebody in community who's needing some help. I know, like, for example, in housing right now, there's so many law changes. People could be getting instances where even the landlords don't know that the law has changed and something's no longer legal. If they've been a landlord for 20 years or something, for example, in some of the new laws, 20-day notices are no longer legal, but people may still be getting those. So letting people know that, oh, actually, that's not legal. You don't need to worry about it in that way, and how to address that with the landlord. Also, I've heard about people already receiving letters, like blanket letters to all tenants from landlords about rent repayment, and already have receiving those letters in May or June. That's not legal. With the rent moratorium, they can let people know about rent assistance programs, but they can't approach them about repayment until July 1. Also, what is in there is they need to come up with they need to offer a reasonable repayment plan. And so sending out something blanket to all tenants in your building, that doesn't meet doesn't meet the law. That doesn't meet the requirement. So really helping people with things like that. Because I've heard of people getting these letters like in May and June and it says in the letter, if you don't, you must sign within 14 days or we're going to start eviction proceedings. Completely not legal.
Yeah, Jesse, you brought up you reminded me of something that I can go hard trying to, because I am so like, I've only ever represented tenants, and so I can go really ham on the tenant side of things. But the other thing I know is that a lot of landlords, they just don't know that the law has changed the way it has changed. Landlords are oftentimes just trying to follow the law as best that they can, and they don't realize they're not following the letter of the law. So that's one of the things that I think is also incredibly important about when we were discussing earlier about avoiding court, is that it's not really the best idea for the landlord to go to court either, because they're going to end up paying an attorney or spending a lot of time to go to court, and they may just want rent to be paid and they don't understand what's required of them. And so the ability to have that conversation and explain what the law is, what the updates to the law are, can really be beneficial to everyone.
Exactly. And the law has like a maximum for rent repayment, but that's not going to be reasonable for everyone. But maybe a landlord doesn't realize that, and they think, oh, that's what I'm supposed to offer.
Mm-hmm.
So really, yeah, helping tenants, weed through that and know what the law is, help the landlord know what the law is in some cases.
Exactly.
Also, as far as like procedural, Josh mentioned, sometimes procedural civil procedure steps are, end up being good defenses too. With the new legislation, with the right to counsel, there has to be a phone number on every summons that's sent out for evictions that has a phone number for people to call to see if they qualify for free counsel. And if the summons doesn't have the phone number, that doesn't meet the procedural requirements. So a lot of new stuff out there right now. Any other questions before we wrap up?
If we don't have any other questions, thank you all so much again for joining us. I apologize. Well, I mean, technology is what it is. We almost had we couldn't figure out the technology 5 minutes before we figured this out, because I don't understand why my computer won't log in personally. So thank you very much for joining us and for granting us the grace of trying to do this presentation twice. And thank you, Jesse. You have been outstanding to present with. And thank you, Denise, for being our fearless leader.
Thank you, Josh, very much for all your expertise and experience you brought to us. And I have had questions about presentation. Yes, everyone, not only that's attending right now, but everyone who registered, we will send out the presentation to. We will also send out a link to the recording. And also, yes, as Denise said, evaluations for the bar. And also asking for, future suggestions and things like that.
Yes, please. I think the future suggestions would be super helpful. We don't know about what folks in the communities would like to learn more about. So suggestions about future topics are super helpful. But if there aren't any other questions, I wish you all a very, very happy Pride Month. Be well and take care.
Thank you so much.